Yes, Madam Crown.
Very well, my lord. My lord, this is the matter of the King against Mr. Andre Bryan, Mr. Tomrick Taylor, Mr. Michael Whiteley, Mr. Dylan McLean, Mr. Lamar Simpson, Mr. Tyreek James, Ms. Stephanie Christie, Mr. Fabian Johnson, Mr. Jazeel Blake, Mr. Royal Taylor, Mr. Joseph McDermott, Mr. Jermaine Robinson, Mr. Andre Golding, Mr. Bryan Morris, and Mr. Ted Prince. They were arraigned before your lordship on the 20th of September, 2021, and were convicted on the 28th of June, 2022, for the following offenses, my lord. Mr. Bryan, who is represented by counsel Mr. Lloyd McFarlane, is present. He was convicted for the offenses of leadership of a criminal organization and 6 counts, my lord, of facilitating the commission of a serious offense by a criminal organization. Mr. Tomrick Taylor, who is represented by counsel Mr. Kimani Brightson and Miss Ayana Campbell. Neither counsel are present, my lord. I'm sorry, counsel Mr. Kimani Brightson is present, my lord. He was convicted for the offense of being part of a criminal organization. Mr. Michael Whiteley, represented by counsel Miss Denise Hinson and Miss Kamisha Mito. Ms. Mito is present, my lord. Mr. Whiteley was convicted for the offenses of being part of a criminal organization and facilitating the commission of a serious offense by a criminal organization. Mr. Dylan McLean is represented by counsel Ms. Venice Brown. Counsel is absent, my lord. Counsel Ms. Mito indicates that she's holding. Mr. McLean was convicted for the offenses of being part of a criminal organization and 2 counts of facilitating the commission of a serious offense by a criminal organization. Mr. Lamar Simpson, represented by counsel Mr. Keith Bishop, Mr. Andrew Graham, and Mr. Janoy Pinnock. Counsel Mr. Bishop is present. Mr. Simpson was convicted for the offense of being part of a criminal organization. Mr. Tyreek James, represented by counsel Ms. Esther Reed and Ms. Davona Wilson. Ms. Reed is present, my lord. Mr. James was convicted for the offenses of being part of a criminal organization and 4 counts of facilitating the commission of a serious offense by a criminal organization. Ms. Stephanie Christie, represented by counsel Mr. Alexander Shaw and Mr. Aston Spencer. Mr. Shaw is present, my lord. Ms. Christie was convicted for the offense of being part of a criminal organization. Mr. Fabian Johnson, represented by counsel Mr. Lindell Wellesley and Mr. Evan Evans. Anyone holding? Counsel Mr. Wellesley is here, my lord. Mr. Johnson was convicted for the offense of being part of a criminal organization. Mr. Jazeel Blake, represented by counsel Ms. Roxanne Smith. Counsel is absent. Mr. Anyone holds? No one holding, my lord. Mr. Blake was convicted for the offense of being part of a criminal organization and 2 counts of facilitating the commission of serious offense by a criminal organization. Mr. Royal Taylor, represented by counsel Ms. Zara Lewis and counsel Ms. Carol Phillips. Neither counsel are present, my lord. Mr. Taylor was convicted for the offenses of being part of a criminal organization, illegal possession of firearm, and illegal possession of ammunition. Mr. Joseph McDermott, represented by counsel Ms. Sasha K. Shaw, who is present, was convicted for the offense of being part of a criminal organization Mr. Jermaine Robinson, represented by Counsel Ms. Roxanne Smith. You holding? Counsel is absent, my lord. No one holds. Mr. Robinson was convicted for the offense of being part of a criminal organization. Mr. Andre Golding, represented by Counsel Mr. Alexander Shaw and Mr. Aston Spencer. Counsel Mr. Shaw is present, and Mr. Golding was convicted for the offense of being part of a criminal organization. Mr. Bryan Morris, represented by Counsel Ms. Denise Hinson and Ms. Kamisha Mito. Ms. Mito is present, my lord. Mr. Morris was convicted for being part of a criminal organization and facilitating the commission of a serious offense by a criminal organization. And Mr. Ted Prince, represented by Counsel Mr. Lyndon Wellesley and Mr. Evan Evans. So Wellesley is present, as indicated earlier, and Mr. Prince was convicted for the offenses of being part of a criminal organization and facilitating the commission of a serious offense by a criminal organization. My lord, I am Kellyanne Murdoch for the Crown, and I'm holding for my colleagues Mr. Jeremy Taylor, King's Counsel, Ms. Claudette Thompson, Ms. Sophia Rowe, and Mr. Dwayne Green. The matter was fixed for sentencing today, my lord. I am in possession of all of the social inquiry reports that were requested, as well as the antecedent reports, my lord.
Okay, thank you very much. Yes, Mr. McFarlane. Very well. Thank you very much, Mr. McFarlane. I welcome the law students here to this sentencing hearing, and I'm sure they should find it an edifying process as a part of their legal training that hopefully will serve them in good stead when they enter the practice of law or commence their career at the bar. So thank you very much, and you're welcome. So let's call upon Mr. Bryan, please. And first person, we will be going in the order on the indictment. And Mr. Andre Bryan, you will be first, represented by Mr. McFarlane. Let me inquire, Mr. McFarlane, you have received the social inquiry report. Just a moment, Mr. Bryan is raising his hand. Yes. You mean addresses the court himself? Okay. Very well.
Bryan, who is standing, does not want that. He wants to address the court himself, and I've indicated to him that if that is the course that he's taking, then I would not be addressing the court.
Very well. Yes, Mr. Bryan, please remove your mask. Yes, good morning, sir. You appreciate that this is the sentencing phase? Okay. And you understand the principles of sentencing? I'm just asking, because... Okay. And that is one of the reasons why you have legal representation, because the sentencing phase of a trial is guided by legal principles. And the attorneys, and specifically now the attorney who represents you, is not only trained but experienced in these matters. And there are ways in which the law indicates that this phase of the trial should be handled. And as far as I am aware, you're not an attorney at law or trained in law. It's not simply no matter of just speaking because you have the ability to speak, but it is also addressing the factors that arise to be considered at the sentencing phase. So, for all those reasons and more, I would recommend that you abide the advice of the attorney to allow the attorney to make his plea mitigation. Beg your pardon? So you wish to speak on your behalf? Okay. And you insist on speaking on your behalf? Okay, well, that's what you have to say then. I beg your pardon?
First and foremost, you
You have a microphone for him? Just a moment. None came up? None is here? None is here? Very well. Is this mic connected to the... Okay, come. Stop there. Stop. Where are the police officers? Come. Both come, and both of you are supposed to be inside the box with him. Come, gentlemen, into the box, both of you. Yes, Mr. Bryan, what is it that you have to say now?
I like to.
Is the microphone on? You turn it
Hello?
off. Yes.
Yeah, morning again, Chief. Morning, court.
I would like to.
Express who am I?
Express.
What I have to say.
Okay. Concerning the sentencing.
Don't really care about the sentencing.
No, well, that is the point that we are at now. This is about the sentencing. So it is not a speech.
Yes,
Generally.
in regard about the
Sentencing now. So we're at the point now we're talking about what is the appropriate sentence for the offenses for which you have been convicted. That is what we're about at this point. And as I understand it, you have been convicted on counts 1, 6, 7, 8, 11, 12, 15, and 19. So that is what we are here to talk about. What you have to say in respect of the appropriate sentence on those counts. So from your start, you don't know, that is another reason why you need an attorney. Do you know what the sentences are?
the guideline.
No, the sentences for the offenses for which you have been convicted.
Lawyer, they give me lawyer, they brief.
Okay. And you are now going to be able to speak to each of the counts.
Yes.
Okay. And the circumstances of each count.
Yes. Yes.
Okay. Now, you have read the social inquiry report.
Just a brief.
You want to read it because it's going to be a part of the sentencing material that is taken into account. Yes. Right. So you wish to read it?
May I have a moment?
Chief,
No. Have you read the report? Would you like to read it?
I'd like to say what I give on the report.
No, we're talking about the whole report now, the entire report. Have you read it?
Chief, I leave it in your hands.
No, no, no. This is why, again, you need the attorney because it's a process.
I understand the
Because
process.
it is clear that you are not fully aware of what the process is and what is involved. So I'm at a loss as to why you are insisting on pursuing this when it is clear that you do not know what you're about.
Maybe to the eyes.
I beg your pardon?
Maybe to the eyes.
No, well, I don't know about the eyes. I'm talking about what is going on here now. Have you seen the report of the police, the antecedent report of the police? Have you read it?
Well, you'd like me to ready to know what I'm doing.
Well, that would be a good starting point.
I read it. I will read it.
I beg your pardon?
I will read it.
Good, so you have to come back down now, go down to the dock, and we give you time to read the document and we go on to somebody else. Right, so while he is familiarizing himself with the relevant documents, we're going on to Mr. Tomrick Taylor. Mr. Taylor. Right. And he was convicted on count 2 alone, correct? Yes. So, counsel, you have had the social inquiry report and the antecedent. So, Mr. Registrar, call upon him, please.
Mr. Tomrick Taylor, please stand, sir. Mr. Tomrick Taylor, you haven't been found guilty on the 8th day of March 2023, Mr. Taylor, to the offense of being a part of a criminal organization. Is there anything you, sir, wish to say to this honorable court before a sentence is passed upon you?
Yes, counsel. Sorry, sir. Just a moment, please. Have a seat, please, Mr. Taylor. Yes.
Irrespective of that, my lord, the social inquiry report confirms that he was not always a victim or a subject or a participant in criminal activities. Some community members expressed surprise. Some were, of course, disappointed. And their disappointment could be attributed to the fact that he was, for want of a better term, better off than some of the other elements that he would have been associated himself with. And I would like or ask or is not beyond rehabilitation, particularly because there are two contrasting forces at play on Mr. Tommy Taylor's life. There is the resilience of a mother figure. There is the presence of a family who, unfortunately, for him that is, are all residing overseas. And again, I will ask His Lordship to find that these are also contributing factors to the vulnerability of Mr. Taylor. But it goes to support our submission, my Lord, that he is not beyond rehabilitation. The report, the probation officer, and I will quote in the recommendation, my Lord, where the probation officer confirms that offenders seemingly had no dire need to have fallen prey to gang activities. This, we are submitting, my Lord, supports the notion that if it is Mr. Taylor was allowed to be reintegrated into this society, my Lord, he would not be without support, a support system, a structure into which he could involve himself and from whom he would receive support. I'm sorry, my Lord. This is his first conviction. And I will use this opportunity to indicate to His Lordship that the legislation itself, the original legislation, my Lord, indicates that first-time offenders who have been convicted of this particular offense is liable to receive a term of imprisonment of 20 years. For second offenders, my Lord, it has been increased, or was increased to 25, as indicated in the legislation. That is direct support of our argument, my Lord, that the fact that not only is this his first conviction, but his first gang conviction, my Lord, should serve somewhat as a mitigating factor on his behalf. He has been in custody since November of 2018, my Lord, and we will submit that from that time and during the duration of the trial, time that would have expired, would have been sufficient for some amount of introspection, my Lord. And that has manifested itself in the interview that was had with Mr. Taylor, in which, my Lord, he has accepted responsibility. He has accepted the responsibility of his actions. He has accepted the responsibility of being a member of the organization. He has accepted that his involvement in the activities of the organization has negatively impacted society. And he supports, my Lord, our argument that he is not beyond rehabilitation. If it is that His Lordship would seek to consider or in applying the principles of retribution, my Lord, or deterrence or prevention, we would submit that the community members or members of the community who were interviewed has stated their claim or stated their position in no uncertain terms that they would wish or they would prefer if he is not allowed to return to the community. I will ask His Lordship to not quickly deterrent, or the principle of deterrence, Mr. Taylor's acceptance of his responsibility and involvement in the organization, coupled with his remorseful pronouncement, my lord, his lordship would not have to lean heavily on that principle. He has learned through introspection, through his continued detention. Mr. Taylor has asked me to impress upon this court that he has seen not the fun but the effects of his actions. And I will use this opportunity, my lord, to recommend for his lordship's consideration the fact that the evidence itself does not suggest that Mr. Taylor was heavily involved in the activities of the organization. On one of the counts, the evidence that was laid in support of one of the counts by the prosecution itself highlights the fact that Mr. Taylor was not present at the penultimate date. And I will ask his lordship to find that his actions as it relates to facilitating that offense, of which he was not convicted, my lord, were, for want of a better term, immaterial or insignificant in the larger context. And I will ask his lordship to find that that particular microcosm is a reflection of the fact that Mr. Taylor himself was not heavily invested or interested in the activities of the criminal organization. He's not beyond rehabilitation. There is no need for imposing a sentence that will weigh heavily on deterring Mr. Taylor after what he has endured, or the time that he has spent in custody. There is no great need for a sentence to reflect retribution or even prevention. And with that, my lord, we are submitting that Mr. Taylor is a suitable candidate for his lordship's leniency. We ask that he impose a sentence that will allow him to reintegrate and reintroduce himself, my lord, to society, and given a second chance.
Yes.
Mr. Bryan has read
Just a moment, Mr. Bryan. Stay where you are, please. Very well.
Again, Chief. Morning again, Chief. Morning, Court.
Good morning, sir.
Can I use this?
Beg your pardon? No, man, there's no need for the Bible.
I like to, when I'm talking, I want to use precept Because the picture where two witnesses them paint and people report evil father. But me no call no man father. Mother tell me something where I'm not sure if him are my father. So me no call no man no father. I, Andre Bryan, which is a subject, the time is now. That is numbers. The time is now to speak. The truth shall be known. Yeah.
Okay, sorry, just a moment. Just before he continues, you call upon him, please. There's a microphone down there.
Mr. Andre Bryan,
Yeah.
you, sir, having been found guilty on the 8th day of March 2023 to one count of leadership of a criminal organization and 7 counts of facilitating the commission of a serious offense by a criminal organization. Is there anything you, sir, wish to say to this honorable court before a sentence is passed upon you?
Just identify the counts for him, please.
Yes, I have
Yes,
something
sir.
to say.
Yes, my lord. So it's count 1, leadership of a criminal organization. Count 6, count 7, count 8, count 11, count 12, count 15, and count 19, all being facilitating the serious commission of, facilitating the commission of a serious offense by a criminal organization. Forgive me. Those are the counts, sir.
See, yes, sir, you can now speak.
Yeah.
So we're going to proceed now. You say what you have to say on this aspect of it, and then your attorney will. Yes.
Isaiah chapter 1 verse 18. Come now.
Sorry, Isaiah chapter 1, verse 18.
Yeah.
Okay.
Come now. Let us reason together, say the Lord. the time coming to court in custody and observing all that my eyes see, entering the court building, first thing, observe, you walk under one arch. And when you walk under the arch, you look on the grill, the architecture, you see erasure. Reach inside the courtroom, observe the courtroom. Even the coat of arms, observe it carefully. People is not aware, most is not conscious. And I didn't get any subject at school. I don't have one. But I understand oneness, consciousness. The motto, out of many one people. Cannot use one with people. First, I cannot use one with people. I'm reading the motto every day. People. One and people. Cannot use one and people. Just feel aware. People say anything loosely, but time spent read the Bible a lot. When I read it, I say like it's an experience, and I find it intriguing based on the things that them say about me. How much thing me order, how much money I start. But the time is now. There is no I. I does not exist. And in English, I is a subject. No one can subject the soul. Us, that are object. The soul is not an object. In the beginning, when God created the heaven and the earth. Genesis 1, verse 1. Going to Genesis 11. Genesis, verse 11. Genesis 11, verse 7. Let us go down there and confound their language, that they may not understand one another. One different from other. Where the corruption came from, Genesis 11, verse 7. The language is ambiguous. The language is a corruption. In the beginning, words don't have any meaning but definition. In, that means you're inside the courtroom. You're in somewhere. In the center, in the middle, you're in. Z, that is the point of the compass. So the point of the composite in overall oscillation. When God created the heaven and the earth, I was in the world. Genesis 1, verse 3. Then God said, let there be light. I was when all of this taking place. But the intriguing thing is, and the earth was without form and void, and darkness upon the face of the deep. Darkness upon the face of the deep. I hear the chief say, the main thing in our case is identification. And now is it time to identify them God. Genesis chapter 1, verse 2. And the earth was without form and void, and darkness upon the face of the deep. One know that face represent present. Face is a metaphor for present. Darkness was up on the face of the deep. One know darkness is blood. Blood covered the present of the deep. Deep, of latter synonym. We're going to go with vibrant. The deep, vibrant. So a Christian them say, the blood of Christ cover me with the blood of Christ. Blood cover the face of the deep, the present. And the Spirit of God move up on the face of the waters. Spirit of God move up on the face of the waters.
Okay, all right, Mr. Bryan. But I want to, but you seem as if you have a lot to say.
No, that's right here. No, not passing Genesis.
No, but you seem as if you have a lot to say.
No, I don't.
Genesis. So what I was going to suggest is that the other attorneys, you see, may wish to
Attorney don't exist now.
no, hold on.
Lawyer represent.
No, but
lawyer is not the present.
But you need to listen to what I'm saying now. It's just because you seem to have a lot to say. What I was thinking is that we
Sorry, my lord.
we allow the other
Okay.
attorneys
With all due respect.
to speak, and
With all
then
due
now we
respect.
get back to you.
Sorry, brother, with all due respect.
So you finish now? Yes.
I will return.
Okay, all right. So we can get on with the others, and then we'll get back to you at the appropriate time. So we'll go with the others, Mr. McFarlane, and then get back to Mr. Bryan.
Another idea.
Yes.
Although he will return,
Yes.
would I be allowed to make my representative at least deal with that, so that at any other time, but it is useful for me to do so in a certain legal framework because it might be easier for my colleagues.
Yes. Very well. a moment. Yes, Counsel.
I represent Mr. Andre Bryan and with me my learned friend Cheryl Richards, who is also present. After the identity trial, Mr. Bryan was convicted of, as indicated, one count of leadership of a criminal organization and 7 counts of facilitating commission of a serious offense by a criminal organization. We are at the point where this court must determine an appropriate sentence for the convicted man having regard to the court's findings of fact. The basic position in relation to offenses charged under the Criminal Justice Suppression of Criminal Organizations Act 2014 that govern this particular case is not any amended legislation as the prosecution here originally started on when they charged offenses of facilitating the commission of an applicable offense. But in fact, the older provisions which charge the commission of a serious offense, and your lordship having brought that to the attention of the prosecution, an amendment was duly made to all of those counts. So that the sentence that your lordship must contemplate would have to be based on the original
Yeah.
charges of the serious offenses. That act, the 2014 act, indicates in the second schedule to that act that in relation to conviction on indictment in the circuit court for the offense of leadership, management, or direction of a criminal organization, the sentence is to be imprisonment for a term not exceeding 30 years. This differs from a conviction in relation to membership of a criminal organization. But that schedule provides that on the first offense, imprisonment should be for a term not exceeding 20 years. We acknowledge the difference that the legislature has indicated in terms of the two offenses. The offenses of facilitating are essentially treated in the same manner. Of not exceeding 20 years. Noticeably, my lord, there is no mandatory minimum sentence in relation to either of these offenses. Your lordship then would start by trying to determine what is the usual range for sentencing in relation to both the that of the facilitating serious offenses. Because these offenses are relatively new, the Act being brought into place in 2014, there's understandably not much material in terms of the courts setting precedents on sentences. One I can recall is the matter where your lordship presided in the Eugene Wilson matter. And that is perhaps the only precedent we have so far that I can refer to. And since it is one case, it's hardly a precedent, but your lordship had tried to set something. But still at this point, we're in the early days, and it is your lordship's sentence that will be setting a precedent in matters to come. So at this point, there is no normal range that I can refer to. What is clear from the sentencing guidelines, however, is that it is not expected that your lordship, in determining its starting point, will start with the maximum. Again, because of the lack of cases, there's not much in terms of precedence in relation to a starting point. What we have then, my lord, is a convicted man before you who has been sentenced in terms of the most serious offense of leadership of a criminal organization. One of your lordship's considerations then is whether or not the court, having found Mr. Bryan guilty in relation to the 7 other offenses of facilitation, whether those should run concurrently. I'm asking that your lordship sentences him for concurrent terms. The sentencing guideline indicates that the sentencing process, your lordship more than one offense. Not be hearing me. Yes, so they are here. Yes, if I might continue, my lord.
Yes.
The sentencing guidelines indicate that where more than one offense is committed in the course of the same transaction, the general rule is that the sentences are to run concurrently with each other. Now, some of these offenses for which Mr. Bryan has been convicted, as for example, counts 7 and 8, which deal with what I will refer to as the new nursery matters, clearly are connected. Again, counts 11 and 12, one charging facilitation in relation to the murder of outlaw and the other charge in facilitation in relation to conspiracy to murder outlaw. Again, I would indicate that these are related. The issue then, my lord, is should the court, in relation to both the leadership of the criminal organization as well as the facilitation offenses, rule that the sentences should run concurrently with each other, as I've asked. If I might refer to paragraph 12.2 of the sentencing guidelines, and just quote it. It says, my lord, in all cases, but especially if consecutive sentences are to be applied, the sentencing judge must have regard to the totality principle, meaning to say that the aggregate of the sentences should not substantially exceed the normal level of sentences for the most serious of the offenses involved. In other words, if I might interpret that, my lord, since the most serious offense here would be the leadership, and that carries a term of imprisonment not exceeding 30 years, what I'm asking is that however your lordship sentences in relation to the others, that the total of those sentences plus the leadership sentence ought not to exceed the sentence that your lordship would have in mind in terms of count one. That is what I'm asking. What are your lordship's considerations, however, in determining what is called the appropriate starting point here? The court, of course, will not have, as I've said, the benefit of a schedule in relation to this particular offense in terms of a starting point, and must, again, find its own starting point. But as I said earlier, and referring to the guidelines, the maximum period of imprisonment provided by statute for a particular offense, which is usually reserved for the worst examples of that offense likely to be observed in practice, will not normally be an appropriate starting point for sentencing purposes. So let us say that your lordship starts in the mid-range on that at 15 for the purposes of my submissions. Then your lordship now will be looking at the aggravating and mitigating factors that the court should consider. I readily concede here, my lord, that the aggravating factors outweigh the mitigating factors based on the findings of the court. Because the guidelines make reference to factors such as the use of violence, use of a firearm, and offenders operating in groups or gangs. The very fact that your lordship has found that there's a gang means that these factors have to be considered, no question. However, happily for Mr. Bryan, there are mitigating factors. The first of those is to be found in the antecedent report of Mr. Andre Bryan, which states that he's a 38-year-old musician of Jones Avenue, Spanish Town. I move straight to that section that says previous convictions, in which it indicates he has no previous conviction recorded against his name, and I also have been provided with a court notification of the fact that there is no recorded conviction. So in relation to the previous good character of Mr. Bryan, I urge that strongly as a mitigating factor. My difficulties, however, my Lord, in terms of mitigating factors, arise in relation to the areas of the offender's capacity for reform, as well as expressions of remorse by the offender. But I will not shy away from dealing with it. In the social inquiry report, Mr. Bryan is reported as having strongly expressed the view not only of his innocence, but that he ought not to have been convicted on the evidence of those witnesses. The problem, of course, for Mr. Bryan is that your Lordship has found as a fact that he did so. And therefore, I would not urge otherwise at this point. What I ask, however, my Lord, is that Mr. Bryan's insistence on his innocence, even to the point of him being allowed by the court to address the court and quote from passages of the Bible, that this insistence ought not to be held against him because Mr. Bryan was originally before the court on 17 different counts, has been convicted on 8 of those, but it also means that he was acquitted by your Lordship on 9 of those. So in relation, certainly, to the counts on which Mr. Bryan was acquitted, his plea of not guilty could be said to have been justified. Going further, his insistence on his constitutional right to be tried on all 17 counts, as I know your Lordship fully understands, ought not to be held against him. Mr. Bryan's insistence on his innocence is supported in the report by a cousin, Miss Julian Davis, who described him as a wonderful person loved by everyone in the community. And she indicated that the family is devastated by Mr. Bryan's conviction, as they believed he would have been acquitted. Ms. Davis further said that he had been wrongfully convicted as he was not engaged in any of the activities he has been connected with. Your Lordship recognizes, of course, that it is all well and good that Ms. Davis is of that opinion, but the court having heard all the evidence found otherwise, and we are bound by that. His father, Mr. Trevor Bryan, who Mr. Andre Bryan just now essentially disowned, also spoke on the matter. And what he had to say was not extremely helpful, except for the fact that it confirmed the fact that he did not play a great part in his child's upbringing. It appears that the father, Mr. Trevor Bryan, had wanted Andre to be converted to Rastafarism, and there was a disagreement between the parents on that. The community response appears to have been mixed. The report says that some residents were tight-lipped when asked about Mr. Bryan, although others were more forthcoming. Some people believe that he is better off where he is, that is, in custody. And others posited that if he experiences sincere reformation, they would not be opposed to him returning to the area. So as I've said, my lord, it's a mixed report. What is more difficult for me to deal with is the assessment and recommendation. And I will only say here that it is an unhelpful position in terms of my... And when I advised Mr. Bryan this morning of the nature of the report, I really should not be surprised that he wanted to speak for himself in relation to that. But now your lordship must go through the processes of establishing a range in relation to these, establishing a starting point, which I have suggested for what it is worth, of 15 years as a starting point, and look at the aggravating and mitigating factors, as your lordship must balance them. At the end of the day, however, I ask your lordship, as the law requires, to bear in mind that Mr. Bryan was taken into custody in relation to this matter in March of 2018 and has remained continuously in custody for, by my calculation, a period of about 5.5 years. Therefore, I ask the court to credit Mr. Bryan with that period that he has been in custody. My Lord, subject to Mr. Bryan's return, that is what I can say to the court.
Yes, thank you very much, Mr. McFarlane. So, I said, Mr. Bryan, because you appear to have a lot to say, we're going to go to the others, and then we'll get back to you. Okay? Yes. Mr. Whiteley? Mr. Whiteley? Okay. A break. All right, Miss Mitu? Just before you, please have a seat, sir. Just before you continue, we're going to have a break of 15 minutes. So we'll rise for 15 minutes and then we will. So rise, please.
And please, this honorable rises, God save the king.
1, mic check.
That not use. Karen could have used this.
You pause the stream, Jeremy.
may be seated, please.
All right, let's do the roll call, please.
Mr. Andre Bryan, Mr. Tomrick Taylor, Mr. Michael Whiteley, Mr. Dylan McLean, Mr. Lamar Simpson, Mr. Tariq James. Oh, bless the Lord. Thank you. Ms. Stephanie Christie, Mr. Fabian Johnson. Okay, thank you, Mr. Johnson. Mr. Jazeel Blake. Thank you, Mr. Blake. Mr. Royal Taylor. Mr. Joseph McDermott. Thank you. Mr. Jermaine Robinson. Oh, thank you, Mr. Robinson. Mr. Andre Golden. Thank you. Mr. Bryan Morris. Mr. Morris, thank you. Mr. Ted Prince. Ah, bless you. My Lord, all present, my Lord.
Okay, now let us get some order here now. Mr. Bryan, where's Mr. Taylor? Whiteley, come forward. You are supposed to be the third person. Mr. McLean, where's Mr. McLean? Come, Mr. McLean. So the numbers have dropped considerably now, so. And Mr. Simpson. Come, Mr. Simpson, come. Next, all right. Mr. James. All right, come, Mr. James, you're next. Miss Christie, come. Mr. Johnson. Mr. Blake. Mr. Taylor. Mr. McDermott. Where is McDermott? Okay. Mr. Robinson. Mr. Golding. Come down. Mr. Morris. And Mr. Prince. Right, so gentlemen, ladies and gentlemen, so that's the order that you'll be in going forward now. All right, thank you very much. So we're now at Mr. Whiteley. All right, so Ms. Smith, do you have any, you have received the,
Yes, my lord, I've received the SCR and its antecedents, my lord.
okay, no questions for the preparers?
No, my lord.
Very well then. Let's call upon him, please. This is on counts 2 and 15.
Mr. Michael Wiley, please stand, sir. Mr. Michael Whiteley, you having been found guilty on the 8th day of March 2023 to the offense of being part of a criminal organization and facilitating the commission of a serious offense by a criminal organization. Is there anything you, sir, wish to say to this honorable court before a sentence is passed upon you?
Yes, please sit, sir. Yes, once.
May it please you, my lord. My name is Kamisha Mito. I appear with my colleague, Ms. Denise Hinser, represent Mr. Michael Whiteley. My lord, Mr. Whiteley was charged with 2 counts, counts 2 and 15, and he was convicted on counts 2 and 15. My lord, I adopt the submission of my learned friend, Mr. McFarlane, as it relates to the law regarding sentencing, and also, my lord, that of my friend, Mr. Bryson, which speaks to the aggravating factors in this case. Also, Mr. McFarlane had mentioned the aggravating factors, and I do adopt their submissions. My lord, you are well knowledgeable as it relates to the principles of sentencing enunciated in the case of Misha Clement and the Queen. Those principles being retribution, deterrence, prevention, and rehabilitation. My lord, you are in the position of balancing sentencing in those 4 areas as it pertains to the society and the accused man before you. We do accept that offenses under the criminal suppression legislation, my lord, are very serious, and the impact it has on our society. And the society wants its pound of flesh, for lack of a better expression, my lord. But, my lord, I ask that when you are approaching sentencing as it pertains to Mr. Whiteley, that you look at him as an individual, my lord, and his particular antecedents. My lord, the mitigating factors that goes to Mr. Whiteley's credit are that, my lord, he has no previous conviction, my lord. My lord, he is a young man. He's 25 years old. He is someone that is not beyond redemption, my lord. He has suffered loss in his life. He had 1 child, my lord, that died when the child was born, my lord. He has also suffered the loss of an uncle, my lord, to violence. My lord would have had sight of his social inquiry report, my lord, and his report, my lord, for the most part is one that is favorable. The report speaks of his relationship with his mother, my lord, that he is the eldest of 4 children, my lord, and that he would assisted his mother in her cook shop, and that because of his incarceration, that business was stopped because she no longer had the assistance of her son. He, my lord, did not have a father figure in his life, my lord, which unfortunately, my lord, we have seen is a recurring theme amongst young men in our society. And this, my lord, has impacted them negatively. And, my Lord, I ask that you take that into consideration, my Lord. The report also speaks to the community members, my Lord. They said they were surprised to learn of his affiliation, my Lord, as they saw no evidence of same. They are pretty much shocked, my Lord, to learn of his involvement in the gang, my Lord, because his demeanor they speak, my Lord, does not purport one to involve these type of activities for which Mr. Michael is before the court, my Lord. My Lord, I ask that in considering a starting point for Mr. Whiteley, that you start at 10 years, my Lord. My Lord, Mr. Whiteley has been in custody for 5 years, 5 months, and 2 weeks from the 12th of April 2018, my Lord. So I ask that credit be given to him for the time he spent in custody, my Lord, and also the fact that he has no previous conviction, my Lord. And the report, the SCR, does speak to that there is no evidence that there will be any escalation in any reoffending behavior, my Lord, which goes to his credit, and that there is no pattern of reoffending, my Lord. My Lord, I would like to address the issue in the report which speaks to the impact and the consequence on victim within the community. Whilst the accused maintains his innocence, my Lord, he does recognize the impact of these offenses on members within his community. He himself having suffered from the loss of an uncle due to violence, my Lord. My Lord, these are my submissions on behalf of Mr. Michael Whiteley.
Thank you very much, Council. Thank you. Next, we have Mr. McLean. Yes, please sit, sir. All right.
Mr. Dylan McLean.
Stand, please, sir.
Mr. Dylan McLean, you have been found guilty on the 8th day of March 2023 to the offense of being part of a criminal organization and 2 counts. Count number 7 and count number 8, facilitating the commission of a serious offense by a criminal organization. Is there anything you, sir, wish to say to this honorable court before sentence is passed upon you?
Right. The Council had his social inquiry report and his antecedents.
Yes, my Lord. May it please you, my Lord?
Please sit, sir. No questions for the preparers?
Yes, my Lord. I do have a question for the probation officer, my Lord.
Okay. Is the probation officer here?
I'm not sure.
Okay, well, I gather that the probation officer is not here at the moment, so that will have to be deferred until the probation officer gets here. Okay, all right. So Mr. McLean, we'll move on now to Mr. Simpson. Mr. Lamar Simpson. Yes, Mr. Bishop.
Yes, please, so please, ma'am.
You have received the SCR and the antecedent report.
I have
Any questions for the preparers?
no question.
Very well, then let's call upon him, please.
Yes, my lord. Mr. Lamar Simpson, please stand, sir. Thank you. Mr. Lamar Simpson. You haven't been found guilty on the 8th day of March 2023 to the offense of being part of a criminal organization. Is there anything, sir, you wish to say to this honorable court before a sentence is passed upon you?
Yes. Please sit, sir.
I will speak at the time.
Yes.
Sorry, seems like the mic was not on, my lord. As I understand it, my lord, the law, my client was found guilty of being part of a criminal organization, and the law prescribes an upper limit of 20 years, but no minimum. So, my lord, my friend was just indicating that I should say that my name is Keith Bishop, primarily for the live stream. That said, though, my lord, I'd like to, with your leave, my lord, just to look at some of and to bring to your attention some of the important details in the social inquiry report, my lord. I shall be very brief since the report is before you. But Mr. Simpson is age 34. And just like the disciples of Christ, he believes in the Christian faith, as can be seen, my lord. The father of 2 children, both boys, ages 16 and 13. And, my lord, he repeatedly indicates to the maker of this document that he's not guilty of the charge against him. And, my lord, he, with respect to the association with his father, it is clear from what his mother has indicated that, well, what he has indicated in the documentation, my lord, that he knew his father as one son, Simpson. Seems like one son is a alias name. And he said, Mr. Simpson said he was raised by his mother, who was abandoned by his father when she became pregnant with him. With respect to the being literate, and his employment history, my lord, I recommend that to your attention just to support the point that he is not someone who cannot be rehabilitated. He is literate, and he has had good employment history and skill training. My lord, I bring to your attention, and I will come back to that while in custody he contracted tuberculosis. And he has been experiencing very stressful situations while in custody. And the community report, my lord, which finds that, based on the community report, no one from the community knows him, my Lord, as any gang member. And they just describe the situation as unfortunate, my Lord, that he's tied up in this. So, my Lord, and just with respect to the antecedent report, to indicate that from the police side, he has no previous conviction. So, my Lord, I should just touch briefly on the not guilty, because there's a little box that was ticked that would suggest that because of that, which is true, he would have no remorse. And I truly believe, my Lord, that someone who believes in his innocent and maintains that ought to have no feeling of remorse, because that essentially is deep regret of guilt for a wrong which was done. And in this case, Mr. Simpson has maintained that he has done no wrong. Notwithstanding the findings of your Lordship and the decision taken at the end, my Lord, that he is certainly guilty, he takes a view that his association with persons who are associated with gangs did not amount to a participation. So as a result, my Lord, I would ask, since in certain circumstances lack of remorse could seem to be something against him, that he be allowed, certainly, his right to feel that he should at least maintain his innocence. My Lord, I'd want to look briefly at the starting point, and I would want to suggest, my Lord, that it should be about maybe 13 years. Only because, my Lord, my client was convicted of one offense. And certainly one of the duties that this court has to perform is to determine what was his participation in the gang. That is an important element that this court has to do, because the punishment must match what this court considers to be his involvement or participation. So, my Lord, if we look at even 13 years as a starting point, my Lord, my next job is to point your Lordships to the aggravating factors. And I just use, my Lord, the aggravating factors as outlined in the guidelines, my Lord, for the sentencing guidelines for use by judges of the Supreme Court of Jamaica and the parish courts. And although, my Lord, I believe, and I stand to be corrected, that these guidelines carry no guidelines, for want of a better word, my Lord, with respect to these offenses that my client is convicted of. It did not include any offense under this particular legislation, but certainly it can be of help, since there are many cases, my Lord, which points to judges using aggravating and mitigating factors prior to these guidelines being implemented. So, my Lord, when we look at the aggravating factor, maturity of the offender at the time, which is about near 5 years ago, he would have been 29. He has no previous conviction, no evidence that there was any attempt to conceal evidence, use of firearm, use of violence, abuse of position, any peculiar vulnerability of the victim, offense committed whilst on bail, that is not so. Offense committed whilst on probation, that is not so. Prevalence of the offense in the community. Offenders operating in groups or gangs. Your Lordship findings certainly would put this against him. Intention to commit more serious harm than actually resulted from the offense. And I think the social inquiry reports deals with that. and did not find that there was any suggestion, nothing at all that would cause that to happen. So I have found, my lord, that with respect to the mitigating factors, there are very few. Sorry, the aggravating factors, my lord. When we look at the mitigating factors, though, my lord, youth of the offender, maturity of the offender, the mental state of the offender, previous good character, she has, absence of premeditation, where appropriate whether reparation has been made, that is not the case, pressure under which the offense was committed, offender's capacity for reform, which we commend to your lordship with respect to his education and training, offender's role in the commission of the offense, where more than one offender was involved, and this is what I was saying, my lord, exactly what was his role based on your lordship's finding. Cooperation with the police by the offender after commission of the offense, family background of the offender, expression of remorse, and this is, I've already addressed your lordship with respect to the remorse on this. So I would think, my lord, that certainly this could reduce, even if we start at 15, this could certainly reduce the starting point 15 to at least 10 years. If when we match up what might be aggravating and mitigating factors. So, my lord, there are other factors that I would ask this court to take into consideration. Firstly, just to expand on it a little bit, the fact that he contracted tuberculosis. And although there's no medical report before this court, my lord, it is well known, and in the report it did say that the offender was infected with tuberculosis. He reported that it has left him with severe shortness of breath, and he now uses a prescribed inhaler called turbohaler. So that alone, my lord, plus possible effects, because if tuberculosis is not caught early, and I'm not trying to give evidence, I'm not a doctor, my lord, but certainly the court might be able to take judicial notice of the fact that this is certainly a serious disease, and if it is not treated properly, it could have long-lasting effect on him. And these are factors that I would like his lordship to take into consideration. My lord, I'm also asking the court to take into consideration what I would regard as prison conditions, my lord. Over the years, so it is not something that I believe judges have seriously taken into consideration. But in recent times, my lord, and I don't have the case before me, there's a case that went before the UK Court of Appeal, and the result, my lord, is that, well, the brief facts, my lord, I just indicate that I had quoted it in, presented that same case in 2 cases at the Court of Appeal in the last 2 years. So it is part of, it has been mentioned in 2 cases, because I was trying to indicate, my lord, that the conditions because of COVID, judges could be a little sympathetic, because in this case, my lord, what has happened is that the offense was sexual offense, and the thinking was that because it's a sexual offense, the accused person should be sent to prison, and he was given a suspended sentence. It was the Attorney General complained, and the Chief Justice thought otherwise, that those conditions, you know, where the prisoners at the time were locked up for 23 hours, they couldn't get visitors, all of those, you know, were things that can be taken into consideration, certainly, so that they would not overcrowd the prison if you could give someone a suspended sentence. Certainly, my lord, is something that someone can take into consideration. But beyond that, my lord, beyond that, although it is dated, the Wolf report that I believe your lordship is familiar with, you know, which is maybe over 32 years ago, did provide an insight into what happened in our prisons. And certainly, I can't say that it has improved. But if I could just read just quickly and briefly, my lord, at page 56 of the said report, it said the task force visited all the adult correctional centers in the island, except the South Camp Road Rehabilitation Center, and the conditions seen in the 2 maximum security prisons namely the General Penitentiary and the St. Catherine Adult Correctional Center, defy description. Overcrowded abounds. Sewage systems are primitive, to say the least, and are in an appalling condition. That both institutions have not experienced the outbreak of serious epidemic is indeed a miracle. The buildings are old and have not been properly maintained. In the case of St. Catherine Adult Correctional Center, damage occasioned by Hurricane Gilbert has not yet been repaired. In the St. Catherine remands, convicted and condemned inmates were mixed. This is clearly most unsatisfactory. At page 58, the quality and quantity of the food provided was extremely poor. At page 59, most inmates spend a large, I'm too fast, sorry about that. At page 58, the quality and quantity of the food provided was extremely poor. At page 59, most inmates spend a large proportion of the day unoccupied. If rehabilitation is an important component of incarceration, then surely every inmate ought to be involved in some form of occupation to instill in them the dignity of honest labor. With respect to medical, at page 62, the quality of medical care leaves a lot to be desired. At page 63, with respect to counseling, there's no counseling facility available to inmates. And, my Lord, what was recommended, which would have been useful, I don't know if it is part of our, any law in Jamaica, but a recommendation made is that the Criminal Justice Reform Act of 1978 should be amended to introduce into the sentencing options the concept of control order. The control order would be threefold in nature. The custody and control order, where the court, in imposing a custodial sentence, could attach a control order. That is to say, a sentence of 10 years would be divided as follows: 5 years custodial, and at the end of which the prisoner would be released. But for the remaining 5 years, he or she would be under the supervision of a control order officer who would monitor the activities of the prisoner with power to place him. And, my Lord, why this is also important in these matters, as your Lordship must be aware, in many other jurisdictions, when persons are identified as gang members, they are taken before the court and orders are made to cause them, to prevent them from getting deeper in gangs, my Lord. Nobody watches them until they are fully involved in the gangs, and then take them to court and cause them to be serving or to be exposed, my Lord, to 20 and 40 odd years in prison. So that is something, my Lord, that I'm not sure is on our books, but for what it is worth, I'm placing it before the court. Sorry. My Lord, what then might be an appropriate sentence for this young man? So, my Lord, if we looked at, if all the factors mentioned are taken into consideration, my Lord, there was indeed a case, and I could say, my Lord, that my source was really an online search where I found it in a newspaper report, but a 22-year-old Jordan Markland, who is said to have been part of a Klansman gang, but nonetheless he pleaded guilty, and he got 10 years in St. Catherine, from the St. Catherine Circuit, my Lord, and the starting point used by the judge based on the report was 15 years, but other factors brought it down, plus I think he was in custody for 2 years. But at the end of it, he was sentenced to 10 years. My Lord, as my friend already pointed out, the starting point at anything near to 20 would be reserved for the worst of the worst, and certainly this is not one of those cases, and there are authorities from the Privy Council as well as our Court of Appeal, my Lord, with respect to proper guidance for a starting point. So, my Lord, at the end of it, even if we are close to 10 years, when the aggravating and mitigating factors are considered, as I understand the law, my Lord, the law, my Lord. So, certainly, those are factors that your Lordship certainly should take into consideration. But, my Lord, I wish to go a little further to say that there might be two or so other considerations that the court could consider. Because indeed, my Lord, we are a Christian society, and generally so. And my client has said that he's of the Christian faith. And if we read, my Lord, Exodus 2, verse 11, I think, where Moses was one of the earlier judges. And in fact, it was clear that one of his roles, my Lord, was to try matters, mediate, and deliver judgments to the flock, to the people around him. And there's another factor, my Lord, which connects Christianity to something called, my Lord, forgiveness. Because, my Lord, it seems to me that it is an important part of making the assessment and arriving at a fair judgment. And if we believe that Christians should at least consider this point, when we look at Matthew 6, verse 14, my Lord, for if you forgive other people when they sin against you, your heavenly Father will also forgive you. But if you do not forgive others their sins, your Father will not forgive your sins. And if we go to Colossians 3, 12 to 13.
I'm just wondering if you're going to be adopting those cited by Mr. Bryan.
Well, my Lord, it seems to be the day for a little of it, my Lord. Therefore, as God's chosen people, holy and dearly loved, clothe yourself with compassion, kindness, humility, gentleness, and patience. Bear with each other and forgive one another. If any of you has a grievance against someone, forgive as the Lord forgave you. All I'm saying, my Lord, these Christian principles should be part of the sentencing regimes. Judges must be reasonable, and they should also lean on the principle of forgiveness as outlined in the Bible. My Lord, I need to look at another point, just to lean a little bit on the Bible, because two things, my Lord. With respect to remorse, I have not seen, and I understand why our Savior Jesus Christ did not say any words at all that you could consider to be remorseful in, my Lord. When he was convicted by Pontius Pilate, he had the greatest of opportunity. All the words said, none of them could be construed to mean that there was any regret or remorse. So, our Christians who are now before you, my Lord, should not be condemned if they say that they are innocent and have shown no sign of remorse. Then, the washing of hands, my Lord. Because it is easy, I would say, my Lord, for any judicial officer to say, what is happening is not my fault. Parliament has made these laws. If you want them changed, talk to Parliament. I'm going to do my part and wash my hands, just like Pontius Pilate did. So, my Lord, it is important that we take responsibility. And I'm going to read, my Lord, two passages. Finally, my Lord, one from the former Chief Justice Wolf of blessed memory, at page 74, when he said, finally and most importantly, we must understand that the offenders are still human beings, and that their incarceration is punishment for their misdeeds, and not for them to be subject to further punishment. With this in mind, the conditions in penal institutions should not be used to further dehumanize the offenders. The conditions must not make of inmates, worse persons than when they enter the institutions. And my Lord,
That's from the Wolf report.
yes, my Lord, that's in the Wolf report. But I will leave, my Lord, since so much turns on guidelines, and this court certainly can forget guidelines if guidelines will not do justice. As you said, my Lord, in sentencing guidelines for the parish court, and I read to you, my Lord, what I believe are your own words. These guidelines are just that, guidelines. They assist in the structure of one's thoughts and actions at the sentencing phase of a criminal trial. The punishment should be appropriate for the crime, the defendant, and the circumstances. There is nothing wrong with departing from the guidelines where the judge sees fit. Departure should be clearly explained. So I would say, my Lord, in the circumstances, and especially with respect to Mr. Simpson's matter, if it requires, my Lord, that departure from the guidelines to do justice, that is what would recommend, my Lord. And your word suggests that this is something that is possible, and certainly this court will embrace it. Those are the submissions that I wish to rely on. May it so please you, my Lord.
Yes, thank you, Mr. Bishop. Let's go on to now to Mr. James. All right, to Ms. Reed.
Yes, my lord,
You have received the social inquiry report on the antecedents.
I have.
Any questions on behalf of either person who prepared, or rather, questions for either person who prepared the report?
No questions.
Okay, very well then. Let's call upon him, please.
Mr. Tariq James, do you, sir, admit to having one previous conviction, which on the 3rd day of December 2018, in the St. Catherine Parish Court in Spanish Town, for the offense of malicious destruction of property, for which you were sentenced to a fine, you were fined $30,000 or imprisonment of 30 days at hard labor? Okay, he admits, my lord.
Said yes or no?
He admitted,
Yes?
my lord. He admitted, my lord.
Okay, very well.
Mr. Tariq James, you have been found guilty on the 8th day of March 2023 to the offense of being part of a criminal organization and 4 counts of facilitating the commission of a serious offense by a criminal organization. Is there anything you, sir, wish to say to this honorable court before sentence is passed upon you?
Yes, Counsel.
Mr. Terry James, sorry, is now 23 years old, 24 years old. At the time that these offenses were committed, Mr. James would have been under the age of 18 years old. He has been in custody for 5 years, 9 months, and 8 days, if my calculation is correct, and I think it is.
Is it 5 years?
9 months and 8 days.
Yes.
My lord, I will draw much on the social inquiry report that was prepared by Mr. Perrier, and I do thank him for his detailed report. Now, the members of the community of Jonestown, or the residents, Jones Avenue, thank you. The members who were interviewed stated that they do not know of Mr. James as a troublemaker. Now, Mr. James was born in Clarendon, and he lived there with his mother and his stepfather until the age of 11 years old. At that time, he went to live with his aunt, his mother having died from an asthma attack. Now, his stepfather was spoken to by the probation officer, and his stepfather was quite alarmed and disappointed to have heard that his beloved stepson, whom he grew to have been a very respectful boy, was convicted in this court for these offenses. Now, Mr. James only knew his father for one day, and the day after he met his father, he was murdered. Mr. James is a young man who is literate. Having looked at the sentencing guidelines, at the mitigating factor at section 9.2, Mr. James, having been a minor for the most part during the time that these offenses would have been committed, was undoubtedly an immature mind. Now, the community response of the report states that residents indicated that he, referring to Mr. James, had to take the rap, and that is in quotation, that is, become involved in the alleged gang activity, as refusing to do so would place his life and that of his family in danger. Persons shared that since his remand, okay, I will take back that last part. But the important point I'm making here is that based on even the assessment of the community, Mr. James, having had such an immature mind at the time when these offenses were committed, was or would have been under immense pressure from those who would have led him down that path. Now, Mr. James, however, has not taken any responsibility for the offenses for which he was tried and convicted by this court. He insists that he is innocent. Now, that being the case, the court normally look at that in a particular negative manner. And all I will say on that is Mr. James and his God knows. But the court has found him guilty, and as such, I do impress upon the court to consider the fact that Mr. James has spent quite a number of his youthful years behind bars. He has lost his youth, or some of his youth, because he's still young. And it is because he is of such a youthful age that I am asking the court that whatever sentence it considers appropriate for Mr. James will be one that will ensure that when he comes back, he will be incorporated into society as he has many more years left in his life. Now, I would impress upon the court that the starting point to be considered is that of 10 years. Now, Mr. Tariq James, in his discussions with the probation aftercare officer, indicated that the affected families are likely traumatized by their experiences of grief and loss, especially considering the circumstances under which the victims reportedly died. He highlighted that gang activity is never something that is positive for a community. Now, a young man who is convicted for being a part of a gang, having expressed such to the officer, is one that I will readily say can be rehabilitated. Because even though he has not, or he continues to impress upon, even upon the probation officer, his innocence, he is aware of how traumatic and how negative gang violence and gang activity is on our society. Now, the community members or residents, they express deep sympathy for Mr. James and his conviction. They believe that he simply fell victim to forces greater than his ability to resist, and that he's not a bad person, and that they are asking the court to afford whatever leniency possible in the circumstances. Now, my Lord, I do ask that Mr. James' sentence will not amount to more than the 10 years I recommend. In fact, I ask of this court that it be less, and that he has had almost 6 years in which he would have looked at his entire life and his likely future. And he is aware that at whatever point he comes back into society, much will be expected of him. So, my Lord, I do ask that all leniency that can be afforded to Mr. James be afforded to him. Those are my submissions.
Yes, thank you very much. It is now at 1 o'clock or 5 minutes past 1. Take the lunch now and resume at 5 minutes past 2.
Stand, please. This honorable stands adjourned until 2:05 p.m. God save the King. Stand, please. Listen, Your Honor. This honorable court is now resumed. God save the king. You may be seated, please.
Right. Yes, could you call the case formally, please?
Yes, my lord. My lord, this is a sentencing matter of the king against Mr. Andre Bryan and others. Representation remains the same. My lord, for the benefit of the writer, we last heard from counsel misread in relation to Mr. Tyreek James. May it so please the court.
Yes, but let us call the names to ensure that. Yes, call the names, please, to ensure that they are all here.
Good afternoon, gentlemen and lady. Mr. Andre Bryan, Mr. Tomrick Taylor, Mr. Michael Wiley, thank you. Mr. Dillon McLean, Mr. Lamar Simpson, thank you. Mr. Tariq James, thank you, sir. Ms. Stephanie Christie, thank you, Ms. Christie. Mr. Fabian Johnson, okay, Sir Johnson. Mr. Jazeel Blake, thank you. Mr. Royal Taylor, thank you. Mr. Joseph McDermott, thanks. Mr. Jermaine Robinson, thank you. Mr. Andre Golin, thank you, Sir Golin. Mr. Bryan Morris, and Mr. Ted Prince. Thank you all. All present, my lord.
Yes, counsel.
May it so please you, my lord, I am, for the record, I am Alexander Shaw, and I appear along with Mr. Aston Spencer for Miss Stephanie Christie. Mrs. Stephanie Christie, that is.
Right. She was convicted on count 2 alone, correct?
That is so, my lord.
Yes.
My lord, there. Oh, very well. I will allow
Thank you.
registrar to call on her.
Thank you, counsel. Ms. Stephanie Christie, can you please stand? Thank you, Miss. Ms. Stephanie Christie, you haven't been found guilty on the 8th day of March 2023 to count 2, which is being part of a criminal organization. Is there anything you wish to say to this honorable court before a sentence is passed upon you, ma'am?
My lord, I will address your lordship.
Well, first things first, do you have the antecedent reports and the social inquiry report?
I do, my lord.
And do you have any questions for the preparers of any?
No, my lord.
Okay, very well then.
My lord, there is an old obiter from Justice Cumming in the case of Gross and O'Toole. And I wish to start there, my lord, because it says mitigation is purported to be the province of the most junior of counsel, but is in fact amongst the most difficult task any barrister can ever face. And, my lord, I say this in the context of a hotly contested trial. And in particular, for Mrs. Cole Christie, as your lordship prepares to deliberate on the punishment that is appropriate in light of the evidence that has been led in this court over the last, 2 years. The critical question is, at this juncture, whether Mrs. Christie is redeemable. And I posit, my lord, that the only place there is no repentance is in the grave. And given that she's in the dock, my lord, I think the difference that we have to confront is that she was exposed to positive social groups as she has expressed her faith, being a member of the clergy. My lord, I want your lordship to consider the case of Daniel Robinson and the Queen. Coming out of our Court of Appeal, particularly paragraph 19, even though our resources are parsimonious in this case, I still provide a copy for your lordship.
No, it's online.
It's online. Very well. My lord,
Yes, we have it here. It's paragraph what?
paragraph 19. And at that paragraph, my lord, the Queen and Sidney Beckford and David Lewis
Yes,
was quoted,
yes.
and there Justice of Appeal Rowe stated, which I think is pertinent to quote at this point.
Yes.
There is no scientific scale by which to measure punishment. Yet a trial judge must, in the face of mounting violence in the community, impose a sentence to fit the offender and at the same time to fit the crime. Lord Justice Lawton quoted the case of the Queen against Sargent and says what ought the proper penalty to be. And the case, my lord, is one of, it was a gang rape matter. He says, we have thought it necessary to only analyze the facts, but to apply to those facts the classical principles of sentencing. Those classical principles are summed up in 4 words: retribution, deterrence, prevention, and rehabilitation. Any judge who comes to sentence ought always to have those 4 classical principles in mind. And tooth for a tooth no longer plays any part in our criminal law. There is, however, another aspect of retribution, which is frequently overlooked. It is that society, through the courts, must show its abhorrence of particular types of crimes And the only way in which the courts can show this is by the sentences they pass. The courts do not have to reflect public opinion. And I want to emphasize on this point, my lord. On the other hand, courts must not disregard it. Perhaps the main duty of the court is to lead public opinion. I know that certainly this court has been doing so, but I go further, as his lordship noted. Anyone who surveys the criminal scene at the present time must be alive to the appalling problem of violence. Society, we are satisfied, expects the court to deal with violence. The weapons which the courts have at their disposal for doing so are few. We are satisfied that in most cases, fines are not sufficient punishment for senseless violence. The time has come, in the opinion of this court, when those who indulge in the kind of violence with which we are concerned in this case must expect custodial sentences. But we are also satisfied that although society expects the courts to impose punishment for violence, which really hurts, it does not expect the courts to go on hurting for a long time, which is what this sentence is likely to do. And, my lord, I stop here for a bit to say that in the context of, well, there's no doubt that gang-related activities, violence, have been wreaking havoc on our society. And the court has to send a message. However, my lord, I agree and I submit that it is the court that has to lead the narrative, because sometimes, as we have seen times and times again, our Jamaican society does not understand how the system works, and so expect the court not to take into account the individual and the particular circumstance, to treat with cases in, I would say, a case-by-case analysis. I go further in the paragraph, my lord. We agree with the trial judge that the kind of violence which occurred in this case called for custodial sentence. Despite his good character, despite the excellent background from which he comes, very deservedly he has had the humiliation of hearing prison gates closing behind him. And that is the case for Mrs. Christie. She has been hearing prison gates closing behind her for the last 4 years. And, my lord, I submit that that is enough, my lord, to act as a deterrent. The court went further that we take the view that for men of good character, that the very fact that the prison gates have closed is the main punishment. It does not necessarily follow that they should remain closed for a long time. And so, my lord, based on the criminal suppression, the Criminal Justice and Suppression of Criminal Organizations Act of 2014, my Lord, the likely sentence for an offense of which Ms. Christie has been convicted is no more than 20 years, given that it is her first conviction for this particular offense. And so, my Lord, if we should, I submit that your Lordship utilize a starting point of 1/3 of that number, which takes us anywhere at 6.5, 7 years thereabout, my Lord. My Lord, the guidelines, the sentencing guidelines, if your Lordship will take those into account, the maturity of the offender. Mrs. Christie is 48 years old, and for want of a better word, one would say that she is not a pup. And why it is that she was, indulged or engaged in this organization. But my Lord, I ask that, notwithstanding the fact that she is the eldest in the gang, my Lord, as the evidence unfolded, there were instances when she would invite, some of her friends to church. And so the question then is, if she was inviting them to church, then why wasn't she, displaying exemplar conduct? But what is true, my Lord, is that there was a constant struggle, because though she was always at church, my Lord, she found herself a part of what I deem a negative social group. And so how do we reconcile that at this point? My Lord, everyone has a struggle. And unfortunately, hers is one that caused her to be here. But the SER which, though we accept, my Lord, there's still bits that is subject to the salacious reporting that we have seen at points where Miss Christie is concerned in this matter. But here, my Lord, she talked about, or she expressed wanting to go back home so that she can lead a better life. As she has been trying her very best from inside the walls of the remand center to do better. My Lord, so looking at the aggravating factors, my Lord, I would urge your Lordship to perhaps add 2 years for that. So to take us to 9 years. But then, my Lord, there are mitigating factors. My Lord, the report says that there is no expression of remorse, but I think it's really a matter of interpretation. And I say this in the context that it is said that she respects the court's decision. And she narrowed it down to, well, she also talked about the fact that, our community would be embarrassed and disappointed in her conduct. And that perhaps she was naive in the way in which she willingly availed herself to the co-offenders, or to her co-offenders. My Lord, I ask that your Lordship don't see her expression of innocence up to the point of the preparation of this report as an aggravating factor. As I submit, well, your Lordship may say it's a very jaundiced view, but I think it is somewhat an expression of remorse. My Lord, recognition of the impact and consequences of the offense. The report states that she did not identify any victims or impact her offense would have had on the community. However, she relayed that her association to this matter would have likely caused the community to be surprised and disappointed with her name being mentioned. Disappointed and surprised, my Lord, because she has recognized the troubles that a gang, or this gang in particular, has caused. My Lord, she has previous convictions which we can't shy away from. She was convicted in 2014, as the report suggests, for dishonesty. But my Lord, I submit that your Lordship don't see it as a graduation of offenses to being a part of a gang. As I submit that there are two different types of offenses. My Lord, in terms of her family, my Lord, the well-respected author D.A. Thomas on the principles of sentencing says that whilst family, crave your Lordship's indulgence so I can tell you the exact page. at page 212, 211, 212 thereabout, the author talked about the fact that the court has stated on many occasions that the hardship caused to the offender's family is not normally a circumstances which the sentencer may take into account. But, my lord, there are exceptions, and one of the exceptions is where the accused person has young children. Mrs. Christie, my lord, has a daughter who she has not been able to see that child attend high school for a day. As for the last 4 years, she has been in custody. A very crucial time for a young lady to have, her mother. And that too, my lord, is also a punishment. And I ask that your lordship consider the impact this has had and continues to have on her. She has expressed in a very penitent letter to me, my lord, to read to your lordship, but because of time, my lord, that
Feel free to read it.
I will just summarize it, my lord. My lord, she talks about how depressing it is to be locked away from her young daughter. My lord, she even went as far as to talk about the suicidal thoughts. As, my lord, the social inquiry report explains it perfectly, how excommunicated she has somewhat been ostracized, because here it says that the interviewer tried to make contact with her husband, who just never wanted anything to do with her or with the matter. She has been shunned, and, my lord, it is because of one who she represented, being a person in the church, and then having found herself here. So, my lord, I'm saying that more than anyone else, she has a demon, my lord, that is of more punishment than even being behind the prison. The shame, the humiliation, knowing that she was the one who was ministering to people. But has been led astray. Now, to divorce her of her own agency, my lord, because one has to confront the role that she has played. But, my lord, she has only been convicted for membership, my lord. And so that I submit, my lord, is something to take into consideration. My lord, her mother, it is said in the report, is an elder, and she is the one who usually take care of her mother. And given that she is not around, it says Miss Robinson, her mother, Miss Sonia Robinson. Miss Robinson voiced that her greatest wish is for her daughter to return home as she is sickly and the offender's teenage daughter needs her support. And despite our best effort as a society to abandon gender roles, my lord, she has a woman has a greater responsibility, I would submit, to take care of, their children, or to nurture. Their parents when they become or when they reach a certain age and their young children. My lord, Mrs. Christie is not beyond rehabilitation. And I say that in the context of she being a business owner, which means that she has the potential to go back into society and lead a good life. It says, my lord, that she was the one, she had a closed store, she used to open and close the closed store, which means that she was also providing legitimate employment to others. She has expressed, not for the first time in this report, but also in this court, that she contributes positively to the community. And it is expressed here again, even though my lord, the report is saying that Mrs. Christie included that over the years she developed an interest in community development and at one point was considered for counselor, but same fell through. She detailed the regularly organized and executed sports and social activities such as football matches on Sunday, sports day, school uniform parties, and annual summer event. My lord, the residents of her community confirmed that yes, they're aware that she would have, sporting activities. So my lord, having reflected on the way in which she has led her life before incarceration, and having gotten 4 long years, your lordship may say, well, listen, her insistence on saying that she is innocent means that she has not learned anything. But sometimes, my lord, when you have, as I've said earlier, when you have contested, sometimes, a trial, sometimes it's just pride. And we have to also understand, my lord, the context of this trial. And I ask that your lordship bears this in mind. My lord, she said that people naturally gravitated to her and respected her. She explains that even now, she's still involved in ministry. That is, she's on the choir, she's in the kitchen, she's trying from inside the detention center to make a good return. My lord, I don't want your lordship to fall asleep. So, my lord, I ask that with all the mitigating factors, your lordship reduce a craver indulgence. My Lord, with all the mitigating factors, my Lord, would discount her 2 years and arrive back at a sentence of 7 years, taking into consideration time spent. I crave for indulgence, my Lord. My Lord, my Lord, well, I was on the point, my Lord, of 2 years. So discount the 9 years, which I arrived at earlier, and 2 years for the mitigating factors. And we also, my Lord, wish to address her previous convictions. My Lord, the SCR does not state a few of the offenses that are disclosed in the antecedent. My Lord, the forgery, the uttering forged documents, etc., my Lord. But as I've stated earlier, my Lord, the nature of these offenses, my Lord, I submit, are not a graduation to something bigger by virtue of she now being convicted for a criminal organization. My Lord, but even if your Lordship should so find, my Lord, it is the first time that she's before the court for being a member of a criminal organization. So that does not take away from the point that your Lordship could still start at 7 and with all the other factors that I've asked your Lordship to take into consideration. My Lord, so having discounted based on my calculation to 7 years, my Lord, she has spent 4 years and 2 months in custody. I have it here, my Lord, that she was arrested on the 30th of June, that's in 2019. So, my Lord, that would take us to anywhere 3 years, 2 years, 3 years thereabout, my Lord. My Lord, and with all that has been said, my Lord, it is on the premise that I understand the message that the court has to send with respect to these type of offenses. But the individual component, my Lord, is critical and crucial. And as was said in the case cited earlier, my Lord, the prison gates closing behind her for the last 4 years, 2 months, my Lord, is in and of itself a deterrent. The mental anguish that she has had to endure by virtue of not being there for her daughter and her other relatives, to include her mother, my Lord. And she, my Lord, it is expressed in the social inquiry report that there are persons in our community who expressed shock. They expressed shocked at the fact that she was a part or she was associating with this criminal organization. So reputation, she doesn't have that going forward, and we'll have to work hard if she will ever want people to see her or to respect her, her dignity, or to restore her dignity, for want of a better word, my lord. I close, my lord, by saying that we ask your lordship for mercy, as my lord, she's still in the dock, and she's not beyond repentance. Unless your lordship requires me to address anything else, my lord, that is the extent of Mrs. Christie's mitigation.
Thank you very much. Just to confirm with her, Mrs. Christie, the police have recorded here that you have 5 previous convictions. You agree or you don't agree? You don't agree? Okay. Let's see how they get the 5. So in February of 2016, St. Catherine Parish Court, Spanish Town, you are convicted of obtaining money by false pretenses. You accept that? You have to speak louder. Okay. Then on the 6th of October 2017, Kingston and St. Andrew. It seems that the indictment had 4 counts. So on one day, 6th of October, there's a conviction for forgery. Yes? Uttering false documents. Fraudulent conversion. The same day. Beg your pardon? Yes, the same day. So you agree with that? That you have a conviction for fraudulent conversion? Well, it's one indictment with 4 charges. Well, at least. Maybe more, but at least. So on the same day, there's forgery, uttering false document, fraudulent conversion, and possession of forged documents. Same 6th of October, 2017. Not sounding? Well, you have agreed to the forgery, yes? And to the uttering forged document. But you're not agreeing with the fraudulent conversion and the possession of forged documents. Oh, okay. Well, the date suggests that it is at the same court, Kingston and St. Andrew Parish Court, and also suggests one indictment with several charges, because sometimes when you're dealing with forged documents, you may have several charges arising out of the one incident. And the several charges now will be captured or written as different counts. Similar to this trial, you have different counts, 1, 2, 3, 4, 5, 6. So this suggests that it is one count, one indictment with at least 4 counts. But you are saying you're not too clear on the fraudulent conversion and the possession of forged documents. Okay. All right, so you have admitted 3 of the 5. So if there's a contest now about the other 2, then the Crown would have to call the evidence to establish those. So we'll do that at some future date. So you can have a seat in the meantime, ma'am. Thank you very much. So, counsel, you're not yet done with your client until this is sorted out.
Very well, my lord.
Yes. Yes, I understand, Ms. Mitu, you wished us to come back to Mr. McLean.
Yes, my lord.
Yes, what is it that you are saying now about Mr. McLean?
My lord, I'm withdrawing the request to pose questions of the probation officer based on discussion with Counsel Ms. Venice Brown, for who I'm holding.
Okay. So you,
I would like to proceed, my lord, with your leave.
okay. Now, just a moment there. Right, yes. Just for the record, just indicate the defendant and your name so the court reporter can have it.
May it please you, my lord. My name is Kamisha Mito. I'm holding on behalf of Counsel Ms. Venice Brown, who represents Mr. Dylan McLean.
Yes.
Mr. Dylan McLean, please stand, sir. Mr. Dylan McLean, you having been found guilty on the 8th day of March 2023 to 3 counts. Count 2 being part of a criminal organization. Counts 7 and 8, facilitating the commission of a serious offense by a criminal organization. Is there anything you wish, sir, to say to this honorable court before a sentence is passed upon you?
Yes, counsel.
May it please you, my lord. My lord, much has been said about the sentencing guidelines from my colleagues who went before. I'd like to address, my lord, as it pertains to Mr. McLean, the aggravating factors in this matter, my lord. My lord, Mr. McLean was found guilty on counts 2, 7, and 8. My lord, counts 2 involves him being a member of a criminal organization, and counts 7 and 8 speaks to him facilitating the commission of a serious offense. The offenses for which Mr. McLean are before the court are very serious, my lord, and the counts for which he was convicted for, my lord, they carry, my lord, violence, and that, my lord, is an aggravating factor, my lord. The impact of these offenses on our society, on the alleged victims, my lord, those are aggravating factors, my lord. But, my lord, when they're juxtaposed against other aggravating factors which one may consider, the use of a weapon, my lord, the vulnerability of witnesses, my lord, the fact that Mr. McLean did not commit any offense, any of these offenses while he was on bail, my lord, should be taken into consideration. Also, my lord, Mr. McLean, in terms of mitigation, he is a young man, my lord. He's 27. At the time he was arrested in relation to this matter, he was approximately 23 years old, which indicate that he was pretty young, my lord, and he would not be operating as someone who is much more mature, perhaps in their 30s or their 40s, my lord. Also, my lord, Mr. McLean suffers from a mental illness. It is indicated in the social inquiry report his mother made reference of same, my lord, and that she had suffered abuse during her pregnancy, which she believed affected her son, and that he was referred to a particular health institution, my lord, for treatment. The probation officer, my lord, in said report highlighted that she was informed that he has been treated for mental illness, where he's currently being remanded, my lord. However, she was unable to have access to his records to confirm same, my lord. My lord, I do have from Mr. McLean an correspondence from the Department of Corrections, which speaks to the type of mental illness he suffers from, my lord. I have provided my friend Mr. Rainford a copy of same, my lord. So, my Lord, I would like for you to take that into consideration as to his mental state, my Lord. I cannot speak to whether he was affected by that condition during the commission of the offense, but what the SCR does indicate that he has been suffering from a mental illness from he was young, my Lord. There is no indication of treatments he would have had prior to him being in custody, my lord. The report also speaks to him being placed on suicide watch, my lord. Also, my lord, Mr. McKilleen is one of a previous good character. He has no offense recorded against him, my lord. This, in fact, would be his first, my lord. There is no indication, my lord, of the presence of premeditation as it pertains to commission of any of the offenses for which he was convicted, my lord. My lord, Mr. McLean is someone that is not beyond redemption. As indicated in the SCR, he is a certified barber. He has training in mechanics, my lord, and this is indicative of the fact that when he is reintegrated into society, he can contribute meaningfully to society, my lord. Oftentimes, my lord, when individuals are placed in custody, they tend to be worse off, and some, my lord, may not have any skill to assist them to reintegrate them into society, but Mr. McLean does have skill that will assist his reintegration into society. My lord, prior to him being in custody, he was gainfully employed. Indication where he would have said the process was not fair, but discussions with Mr. McLean indicated that it's not in terms of the actual process of calling witnesses, cross-examination. It's in relation to the fact that one of the witnesses did not identify him during the identification parade process before the trial commenced, and then later during the trial process identified him in the dock. He stated that that was the unfairness that he referred to and not regard to the trial process, my lord. So I ask that my lord may not hold what was said in the report pertaining that against him, my lord. And also, my lord, when one looked at the report, is referred to as someone that is simple-minded, my lord, which speaks to his ability to properly assess, comprehend, and analyze situations, my lord. The community in which he is a part of, my lord, they indicated that he is a simple person who has a good family background and was generally gainfully employed. They also indicate that they were surprised when they heard his name being called in the gang, as he has never portrayed that character, my lord. Other members indicated that his association may have been risen due to the fact that he is a neighbor of black man, in quotes, my lord. Overall, my lord, the social inquiry report of Mr. McLean is one that is favorable, and it does indicate that he is someone that is not beyond redemption. He, when reintroduced into society, can contribute to a better Jamaica, my lord. These are my submissions.
Right, thank you very much. And now, Mr. Fabian Johnson. His counsel is here. Yes? Okay, let's go on to Sir Jazeel Blake. Mr. Leslie, your client is... Okay, we'll take Mr. Fabian Johnson first. Okay? Okay. Right, Mr. Fabian Johnson. Right. Yes, Mr. Leslie. Is it Mr. Fabian Johnson? Yes, go on. You have received both reports, Mr. Leslie. That is it.
My lord.
Any questions for any of the preparers of the antecedent or the social inquiry report?
No, my lord.
Where were they?
I have no such instruction.
Mr. Fabian Johnson, you haven't been found guilty on the 8th day of March 2023
Sam?
to the offense of being part of a criminal organization. Is there anything, sir, you wish to say to this honorable court before sentence is passed upon you?
I am Lyndon Wellesley. Myself, Mr. Evans. We do represent Mr. Johnson and Mr. Ted Prince, but we'll read Mr. Johnson first. My lord, I am but a messenger and a conduit, and I describe myself as a mendicant with a task seeking mercy from your Lordship on behalf of Mr. Johnson at this stage. Let me say without hesitation, my Lord, I would adopt the submission of Mr. Bishop, my colleague, and also of Mr. McFarlane in relation to the first offense on which he is charged, being a part of a criminal organization. I would hasten to say, without hesitation, Lord, that Mr. Johnson apologizes for any hurt, harm, that anyone has suffered or experienced as a result of being part of what is charged. Say to error is part of human frailty. Mr. Johnson has been in custody for approximately 4 years. And I would submit, my Lord, that your credit will be given to him during this time of his incarceration. He has no previous conviction, my Lord. And I humbly ask that your Lordship, in exercising your judicial function, sentencing Mr. Johnson, you draw on your fatherly instinct, wisdom, and judicial experience. Because, Lord, I submit humbly that he is not redeemable. He is not. He is, let me put it another way, my Lord. Put it this way. The purpose of sentencing, my Lord, is for, one, to punish the offender, two, reform and to deter. Mr. Johnson is not one with whom trust of reformation cannot be handled. Because no one is irredeemable. None. Part of it.
No one is irredeemable.
So, my Lord, I liken Mr. Johnson to a train that has been derailed. And we humbly ask that your Lordship uses your judicial hands and the mercy which we sought to put the train back on track. Despite what is in the report, my Lord, My instructions are that Mr. Johnson is seeking the mercy of the court. He has 2 children from which he has been separated. And we humbly ask, my Lord, that the separation intended will and shall not be too long, my Lord. On your determination, your hands, my Lord, we await your judicial pronouncement. And we humbly ask that the hands of mercy be extended to Mr. Johnson. It pleases you, my Lord.
Thank you.
Mr. Prince.
Mr. Ted Prince now then.
Yes, my Lord.
Yeah, Mr. Ted Prince. You have received the reports in respect of him, the SCR and the antecedents.
I have, my Lord.
Any questions on behalf of the makers or preparers of the reports?
I have no such instructions to that night.
Okay. Very well then. Thank you.
Mr. Ted Prince, please stand. Mr. Prince, good afternoon. Mr. Prince, do you admit to having 4 previous convictions over 3 dates? The first being the 8th of January 2013 in the St. Andrew Halfway Tree Resident Magistrates Court at the time for housebreaking and larceny, where you were sentenced to an imprisonment to 2 years at hard labor, sir? Okay, my lord, he admits to the first conviction, my lord. The second conviction and the third are on the 18th day of July 2018. The second being this is at the Kingston Gun Court, for illegal possession of firearm, and the second, illegal possession of ammunition. You were imprisoned for 8 years at hard labor to run concurrently with an imprisonment for 4 years on the illegal possession of ammunition at hard labor. Do you admit to these 2, sir? Thank you. And the fourth and final, on the 14th day of April 2023, Kingston in the Home Circuit Court, contempt of court. You're imprisoned for 60 days at hard labor. Thank you very much, sir. My lord, the accused, the convictors admitted to all 4, my lord. Mr. Ted Prince, you have been found guilty on the 8th day of March 2023 to 2 counts, that of being part of a criminal organization and facilitating the commission of a serious offense by a criminal organization. Is there anything you, sir, wish to say to this honorable court before sentence is passed upon you?
Yes, counsel.
Lord, I'll begin by saying, he who hath not sinned cast the first boulder, not stones. My Lord, I humbly ask that you draw on your judicial wisdom in sentencing Mr. Prince. Mr. Prince has admitted his infraction of the law, and I would submit that it points to his honesty. My Lord, we ask that you hold that not against Mr. Prince and sentencing him, but extend your judicial hands to him so that it can be said, your Lordship was merciful to Mr. Prince, who I think is a sinner just like myself, my Lord, or all of us, who I think is a sinner like all of us. My Lord, we kneel before you humbly for the mercy which floweth from your Lordship's judicial hands. And of course, at the end of the day, my Lord, I am confident that justice will be done in your sentencing, if it pleases you, my Lord.
Thank you very much.
I think he's serving a sentence presently, if I'm not mistaken.
How long has he been in custody for this matter?
Could I? I agree, Your Lordship. My Lord, he has been in custody from March 16, 2018. Those are my instructions, my Lord. And if there's anything else your Lordship wishes or intends to inquire into, and can assist the court, my Lord, on behalf of Mr. Prince, I'd be more than willing to do that, my Lord.
Just in respect to the firearm offenses for which he was convicted, was he on bail? Because of
He said no, my Lord.
I asked because of he says he was in custody in March 2018, and then the convictions there took place on the 18th of July 2018. So I was just wondering whether he was on bail, then he was taken into custody on this offense, and then the trial for the firearm offenses took place in July.
My Lord,
Yes.
my instructions are that he was in custody when he was charged on this offense.
All right. Yes, thank you very much.
I'm indeed grateful.
Right. So we are now at Mr. Blake. That's you, counsel?
No, my lord, but I've not seen counsel for Mr.
You represent,
Mr. Taylor, royalty.
okay, let's go to Mr. Royal Taylor then.
May it please you, my lord, just to confirm that I have received the antecedent report and the social inquiry report in respect of Mr. Taylor, and I have no questions for the police officer or the probation aftercare officer.
Okay. Thank you very much.
I have no questions, my lord.
Yes.
Mr. Royal Taylor, you haven't been found guilty on the 8th day of March, 2023, to 3 counts on this indictment. Count 2, being part of a criminal organization. Count 23, illegal possession of firearm. And count 24, illegal possession of ammunition. Is there anything you wish to say to this, Honorable Court, before sentence is passed upon you, sir?
Thank you, my lord. My lord, I would start by adopting my learned friend's submissions to you on the concept of mercy. And I would also urge upon your lordship the poem by Sir William Shakespeare on the quality of mercy. And it begins, Sir William Shakespeare, thank you. The quality of mercy is not strained. It droppeth as a gentle rain from heaven upon the place beneath. It is twice blessed. It blesseth him that gives and him that takes. My lord, as your lordship approaches the sentence of Mr. Taylor, I would urge your lordship to consider the principles as outlined by our learned Court of Appeal President, Justice of Appeal Morrison, in the case of Misha Clement. Now, at paragraph 41 of that judgment, his lordship outlines a summary of how a court should approach sentencing.
Sorry, the name of the case is?
Misha Clement and well, it was the queen at the time, but now it's the king. Okay. 1, identify the appropriate starting point. 2, consider any aggravating features. 3, consider any relevant mitigating features, including personal mitigation. And 4, consider where appropriate, well, this is not appropriate, any reduction for a guilty plea, and decide on the appropriate sentences, giving reasons, my lord. My lord, in identifying the appropriate starting point for the offender, your lordship is urged to look at the antecedent of the offender, which is set out, firstly, in the antecedent report provided back to the court, which shows his name, date of birth, education, employment, marital status. But it more importantly highlights that Mr. Taylor has no previous convictions. Your lordship may also look at the social inquiry report, which also sets out the personal biography of Mr. Taylor, which I will not go into at this time. But I will look, your lordship, at the community response to Mr. Taylor.
They observed him to be quiet and industrious as he plies his skill as a barber and as a furniture maker. They also express mixed reactions, but I note here that the mixed reactions are explained. They say they do not know of him to be involved in any criminal activity, and some assert that it may have been a setup against him that he was convicted. My Lord, this is the community's response. Not to take away from any finding that your Lordship has made. My Lord, in assessing now what is the starting point for an offender like Mr. Taylor, I would adopt the sentencing guidelines in respect of the illegal possession of firearm and ammunition, which is 10 years and for firearms and 4 years for ammunition, with the normal range for the firearm possession being 7 to 15 years, and the range for the ammunition being to 3 to 7 years, my lord. The guidelines are, however, silent on the normal range for the offense under Section 2, which is being part of a criminal organization, the Criminal Justice Suppressions Act. In that regard, my lord, has to take into account the personal antecedents of Mr. Taylor, as well as the prevalence of this offense in the community and society's aberration or annoyance to this type of offense. The maximum is 20 years as set out in the Act. However, my lord, I would urge upon you that based on the personal antecedents of Mr. Taylor as outlined in the antecedent report and the social inquiry report, that the starting point for Mr. Taylor ought to be 7 years, and I would submit that to you. Now, my lord, having assessed the starting point, your lordship would then be able to look at is then urged to look at the aggravating features of the offenses and then the mitigating features that are personal to the offender, Mr. Taylor. Now, in respect of the aggravating features, the prevalence of this offense, as set out at paragraph 33 of the said judgment, they give a list that they say is not exhaustive. They say we are to look at, it's at paragraph 32. The previous convictions, which Mr. Taylor has none. The premeditation, and we'd submit that there is none here. The use of a firearm, well, that exists, so that would increase the sentence. The abuse of a position of trust, the offense committed while on probation, that does not apply. The prevalence of the offense in the community, and the intention to commit a more serious offense. I would say that the aggravating factors that apply would be the prevalence of this offense in the community. Your lordship is therefore urged, having assessed the aggravating features, to look at the mitigating features that are particular to Mr. Taylor. One, his age at the time of the offense, that is set as 43 in the social inquiry report. His previous good character, he has no previous convictions before you. My lordship, where reparation does not apply, nor the pressures under which this has taken place. The offender's capacity to reform, and there is, in Mr. Taylor's case, given his industry and his previous good character, there is a good capacity for reformation. And the offender's role in the commission of offense. Now, in respect of count 2, my lord, there was no other count that he was joined on that was gang-related. He had single counts, my lord, in respect of the possession, but he was not enjoined in any gang-related count. So in respect of his role as a gang member, I would submit that he would fall at the very low ranks of the gang, and that should be taken into account in assessing his mitigation. Now, having done that assessment, my lord, your lordship is urged by the cases of Callahard and the state from the Court of Appeal of Mauritius to look at any time spent in custody and take that away as an arithmetic deduction in its entirety. And that would be, in Mr. Taylor's case, since he was arrested on the 3rd of June, 2019, would be a deduction of 4 years and 3 months, my lord. And so if the starting point is 10 years and there are several aggravating features, we would submit that Mr. Taylor ought to be sentenced to less than 7 years. No, for the illegal possession. So the 10, and then you take away the 4 years and 3 months, the aggravating factors would push it up by a year, my lord, and then it would the mitigating factors, my lord, I would submit would take it down to another 2 or 3 years. So Mr. Taylor should serve no more than 5 years on the illegal possession of firearm. He should have time served on the ammunition offense. And in respect of count 2, my lord, he should also have time served. If it pleases you, my lord, those are my submissions.
Yes, thank you very much. Right, thank you. This is Mr. McDermott.
Yes, my lord. My lord, if it's so please, for the record, my name is Sasha K. Shaw. I represent Mr. Joseph McDermott. My lord, I have received the social inquiry report as well as the antecedents for Mr. McDermott, and we have no questions.
All right, thank you very much.
Mr. Joseph McDermott, sir, you haven't been found guilty on the 8th day of March, 2023, to the offense of being part of a criminal organization. Is there anything you, sir, wish to say to this honorable court before sentence is passed upon you?
My lord, if it so pleases, Mr. McDermott is, before you having been convicted of under Section 2, being a part of a criminal organization, my lord, I will start with speaking about the appropriate starting point, my lord. And in doing so, I would ask my lord to look to the case of Aguilera and others in the state, and if my lord has it online.
Case of?
Aguilera and others and the state, 2016 89 WIR 451.
2016, what volume of the West Indian reports? You said something about WIR?
WIR
What volume? What's the number?
84, 89.
Four.
Sorry,
Right.
89, madam.
And page 1,
451.
451. Yes. Yes.
My lord, I draw your attention to page 453. Paragraphs A and B says, in calculation of the starting point, which should take into account the aggravating and mitigating factors of the offense only. Those were the objective circumstances which related to the gravity of the offense itself and which assisted in gauging its seriousness. My lord, I asked you to recall the
facts as it relates specifically to Mr. McDermott in what that was used to ground his conviction. My Lord, I submit that his participation based on the facts was minimal, and therefore the starting point should reflect what it is alleged that he had done in respect of this matter, or what role he played in the commission of these offenses. And it's my submission, my Lord, that Mr. McDermott's role was so minimal when compared to others that the appropriate starting point for Mr. McDermott should be 7 years. I know my Lord would then go on to factor in the aggravating factors, which are the prevalence of the offense in the community, the offenders were operating in groups or a gang. I ask my Lord to consider, and I will urge upon you the mitigating factors. My Lord, Mr. McDermott is 29 years old now, but in 2015, during the period to which the offenses are said to have taken place, in 2015, Mr. McDermott was 21 years old. In 2019, he was 25 years old. My Lord, I ask that you find that Mr. McDermott was young, relatively immature, not yet old enough that the decisions that he makes would have had more consideration as to their consequences. The risk of being influenced is high between that age range, my Lord. And so I would ask you to take into consideration his immaturity at the time of the commission of the offenses. I also ask my Lord to take into consideration his previous good character. Mr. McDermott has no previous convictions recorded against his name. This is the first time he has had any interaction with the law. I'm also asking my Lord to take into consideration the time that he would have been in custody in respect of this matter. Mr. McDermott was arrested on the 27th of June, 2019. So he has been in custody for 4 years, 2 months and 21 days in respect of this matter. I also urge my Lord to find that given that Mr. McDermott had no previous convictions, that this would qualify him as for a term not exceeding 20 years under the legislation. My Lord, I will now move to the social inquiry report. My Lord, Mr. McDermott maintains his innocence. Whilst remorse is a mitigating factor, my Lord, it is not an aggravating factor if we are to look at the list that the sentencing guidelines provides. I am asking, my Lord, that his lack of indication of remorse not be used against him. My Lord, I also urge upon you to consider his family, his family background. Mr. McDermott appears to have a supportive father, as well as aunts who reside out of parish. He is able to, at some time after he has served his sentence, to have some support that he can be reintegrated into society. From all indications, after he has left school, my Lord, he has been working. He has worked with his father up until the time of his arrest. His father has been very helpful. In fact, he has provided him with a workshop which he could have operated from. And so, my Lord, he is not someone who is unsupported. My Lord, I would go to the community's response. My Lord, 2 communities were visited in respect of Mr. McDermott. He has indicated that he resides in Damshire Pen, and the community of Jones Avenue was also visited in respect of Mr. McDermott. My Lord, the residents of Damshire Pen relay that he is mannerly and helpful, and they have indicated that whilst they have not seen him or heard of him being involved in any criminal activities, they have seen him in the company of members of the organization. We admit, my Lord, that the information from Jones Avenue is not favorable, but we ask, my Lord, to consider the now facts that are before the court in respect of what it is alleged that Mr. McDermott would have done. My Lord, we are asking for you to consider that Mr. McDermott is not someone who, if given the chance, could change. If he were to be introduced into society, he has not yet formed a pattern of offending. So he's not someone who we can deem to be, if he is released at some later stage, the likelihood of him reoffending is live. And although, my Lord, the probation officer finds him a high risk to society, as well as to known adults, we are asking, my Lord, to go back to what it is actually alleged that Mr. McDermott did, and we are asking, my Lord, to consider that the residents of Jones Avenue are of the opinion that his involvement was forced because of his family members being threatened and not being done of his own will. It is concerning, my Lord, because we know how young men are targeted in some communities, and we accept that that is something that certain persons in our society face and are a real risk that they are susceptible to. But, my Lord, we are asking that you deem Mr. McDermott as not being the worst of the worst. And we ask for your leniency given all the circumstances of this case, and unless my Lord has any other.
All right. Mr. Jermaine Robinson, councillors. No. Andra Golding.
My Lord, I was, with your leave, my Lord, I was permitting Miss Mito to go with your leave, my Lord, so I could come back tomorrow, having spent almost an hour earlier. I think I have a lot to say.
Oh, you have a lot to say. Okay. Okay, Ms. Mito, this is Inspector Mr. Morris.
Yes, my Lord.
Okay.
May it please you, my Lord. My name is Kamisha Mito. I, along with Ms. Denise Hinson, represent Mr. Bryan Morris. My lord, I do have the probation report and his antecedents to hand, my lord.
Any questions on behalf of the makers of?
No, my lord, no questions.
Okay.
Mr. Bryan Morris? Mr. Bryan Morris, you haven't been found guilty on the 8th day of March 2023 to 2 counts. The first count being for being a part of a criminal organization, and the second one is count 15 for facilitating the commission of a serious offense by a criminal organization. Is there anything you, sir, wish to say to this honorable court before a sentence is passed upon you?
Yes.
May it please you, my lord. My lord, I will begin with the mitigating factors as it pertains to Mr. Bryan Morris. My friends who went before me, my lord, and having done Mr. Whiteley and Mr. McLean, my lord, had made reference of the aggravating factors in this matter. I will now direct your attention, my lord, to the mitigating factors as it pertains to Mr. and adopt the aggravating factors for those who went before my lord. My lord, to hand, I have Mr. Bryan Morris antecedents, my lord, and it indicates that Mr. Morris has no previous convictions, my lord. So I ask, my lord, that you take that into consideration when handing down your sentence. My lord, Mr. Morris has spent 4 years and 3 months in custody. He was arrested on the 25th of June 2019 in relation to this offense, my lord. So I ask that you apply the relevant discount for the time spent in custody. Mr. Morris, my lord, is presently 28 years old, my lord. And there is an aspect of his social inquiry report, my lord, in terms of the assessment and recommendation where Mr. Morris has concern for the uncertainties of his future, my lord, particularly that of his lack of accomplishments. My lord, I bring this to your attention to point to the fact that Mr. Morris, who is now 28, has had the opportunity to develop his mind where he is looking at his self, he's doing self-introspection, my lord, as compared to when he was a teenager in his early 20s, my lord, where his mind was not fully mature. Now he is at that juncture in his life, my lord, where he's doing some self-introspection, my lord, which speaks to his mind developing, my lord. And this, my lord, is part of a mitigating factor when one is considering sentencing. The age of the accused at the time the offense was committed, my lord. At the time he was relatively young, my lord, and his reasoning abilities were not fully developed as compared to now, my lord. My lord, Mr. Morris has been gainfully employed. The report indicated that he was a laborer, my lord, that he would also work as a welder while he was, before he was arrested, my lord. The report also speaks to him being a shy quiet individual who kept to himself, and his parents expressed that his arrest was a shock to them, as that's unlike him. When he was younger, my Lord, he was a member of this community 4-H club, my Lord. So he was participating in a positive manner in his community. And the social inquiry report speaks to that positive involvement in community-based activities, my Lord. My Lord, I would like to highlight the section of the report that says does the offender recognizes the impact and consequences of the offense on victim and community. Mr. Morris, as it says here, indicates his innocence, my Lord, which should not be held against him, my Lord. He has gone through the process of trial and he has respected that process, my Lord. Notwithstanding, say, my Lord, he still maintains his innocence. He, however, indicates that he understands that offenses of this nature would have a impact on members of the community. It would cause them to be scared or frightened, my Lord. So he does understand the impact of these offenses for which he is convicted on members of the community, my Lord. So there is an appreciation, my Lord, of the impact these offenses have on society. Also, my Lord, the report indicates that there is no form or pattern of reoffending as it pertains to Mr. Morris, and that there is no escalation in seriousness of his behavior. So, my Lord, I ask that when considering Mr. Morris, that you be lenient, my Lord. These are my submissions.
All right, thank you very much. It is now almost 4 p.m., so we'll be continuing tomorrow with those pleas in mitigation that have not yet been heard, and that's in respect of Mr. Jazeel Blake and Mr. Andra Golding. That's about it. And for Mr. Bryan, wasn't that done? And Mr. Jermaine Robinson. Let me, hold on. Just a moment. Oh, it was Joseph McDermott. Okay. All right, so let's take the adjournment now until tomorrow, please, at 10.
Stand, please. This honorable court stands adjourned until tomorrow 10 a.m. God save the King.